We even have a webcam, high tech. That's our speaker.
Thank you. For those that are logging in, we're getting situated here. And tell me who's online besides Emmanuel.
Horace Clark.
Andrew Titler.
Okay.
Kathleen Carr.
Okay. Anyone else?
This is Laura Brown.
Okay. Anyone else?
Karen Dunnigan.
Yeah, I can see some other names, Lori, on the WebEx.
Yeah, I see them. They may not necessarily be on the call quite yet.
Right.
But I can try to do roll call. Barbara? Dana? Joe? Yep. Okay. I'm sure they'll sign on. One of these things. I'm trying to. Yeah, I'll tell you. I'll take a moment.
No, you got it.
Thank you, Yusuf.
The mountain.
Well, in the essence of time, 5 minutes after our start time, so I think I have just about everybody that is online. So did I get Dana? Dana, are you online? Joe?
Yep, I'm here.
Barbara? Okay. Well, if you come online after at some point, please let us know, and then we'll go from there. All questions can be addressed, and Karen will be able to go ahead and answer them. If they're organic during part of her presentation, please feel free to ask them. And with that, I will turn it over to Mike Berrigan, who will give us our introduction.
Well, thanks, Lori. So quick introduction of Karen. So she's been on board for about 2 months now as our new and first director of our employment litigation and labor unit. And she's in the process of standing up that first national practice unit for solicitor's office. Let me just spend about half a minute giving you a brief background on Karen and why she is eminently qualified to instruct on what she's about to do. So for the last 8 years, she was at DEA, and she was the Associate Chief Counsel in the Civil Section. She helped create new policy on reasonable accommodation and the procedures for processing reasonable accommodation. She created training modules for managers on reasonable accommodation and gave it to managers. She also taught at DOJ's NAC, National Advocacy Training Center down in South Carolina. Before that, she was at federal programs at DOJ for well over a decade. Did a lot of high-profile litigation, including class action Title VII cases. And closer to home, she was lead counsel on RAMA. As she likes to say, she won RAMA before we settled it for over $900 million. But she's intimately familiar with some programs at Interior before getting here. Before practicing, she clerked at the Third Circuit, and she's a member of the Texas Bar. So we very much look forward to her training. And Karen, without any more ado, turn it over to you.
Thank you for joining us, and I'm happy to be able to provide you with 2 hours of EEO training, so you can check the box on that. I chose this topic, one, because Horace and I were speaking the other day. It is probably the biggest problem that agencies are facing in terms of losses in this area of the law, in the EEO world. This is the one area that is the most problematic. It's not intuitive. It is complicated, and so I'm hoping that you will, leave today after two hours and not want to kill me, but we'll learn something. And so feel free to interrupt me. I want this to be an interactive process, and I'll describe what that is as we go along. So,
Hey, Karen, this is Matt McCowan. Is there any way to get some more volume from you?
We just moved it closer to her, Matt.
Thank you.
is this it right there? Can you hear me now?
It's not great, but I guess that's as good as we're going to get.
I'll hold it right next to my mouth. How's that? Better?
No.
No.
I wonder if that's on.
I'm going to move down one seat to see if that works.
I wonder if the main
Try sitting
piece
here.
would work better.
All right, is that better?
Yes.
So let's talk about the objectives of, now my, oh brother, where are the tech people?
As if you get, Harry. I thought I was training.
It's just not working at all. I wonder if this,
Did we lose you?
oh, we're here. It's,
Oh, okay, okay.
I guess we're having technical difficulties with the PowerPoint.
There you go. It just fell asleep.
Fell asleep. Here we go.
PowerPoint?
PowerPoint. So the training objectives today is learning about our responsibilities to individuals with disabilities, to learn how to identify when a request for accommodation is being made. That's probably the biggest problem that managers face, is they don't know when they're supposed to accommodate because they don't recognize when the problem occurs. So we'll be talking about that. The second biggest problem is understanding the interactive process. You can legitimately deny a request for accommodation, but if you have not engaged in the interactive process, you will be held liable. So this is an important aspect of the reasonable accommodation process. We're also going to be learning about how to identify when an accommodation is reasonable and when it is not, how to deal with resources. Payment to some of these things are challenging, and especially with our challenging resources in these days, and so finding how to finance these accommodations is a difficulty. And understanding record keeping and confidentiality requirements. So the legal requirements are pretty simple. They come from the Rehabilitation Act of 1973, and the Rehabilitation Act is the sister act for the Americans with Disabilities Act, which applies to private employers. The Rehab Act says that federal agencies must reasonably accommodate qualified employees or applicants with disabilities unless to do so would cause an undue hardship. We'll talk about what an undue hardship is. An EEO complaint can be filed by any employee or applicant who feels that they have been improperly denied reasonable accommodation. It is part of the EEO process. A lot of managers don't know that. And the agency can and oftentimes is held liable for failure to accommodate. What is an accommodation? A reasonable accommodation is removes barriers that prevent employees from performing their job functions, or that prohibits or creates obstacles for applicants to apply for jobs with the government. So it's called breaking down the barriers. We're trying to create accommodations so that they can be on a level playing field. There is a distinction between disability discrimination and failure to accommodate. Disability discrimination goes to motive. So the example I gave here is a supervisor has a bias against someone with mental disabilities, and because of that, decides not to promote them. That is disability discrimination. It requires a showing of bias. The person doesn't like people with a disability, so therefore that is disability discrimination. For failure to accommodate, you can like people with disabilities, fail to accommodate them, and still be liable. So you don't have to have a showing of bias. Here are some examples of accommodations. A lot of you are familiar with making facilities, bathrooms, doors accessible to people with obvious disabilities. That's the easy one. The other ones are a little more difficult. So restructuring non-essential duties of a job, and we'll talk about that. Adjusting policies so that as an accommodation is oftentimes what we have to do. Authorizing part-time or modified work schedules, and acquiring or modifying equipment. And as a last resort, reassigning employees to a vacant position if they can no longer perform their job.
Hey, Karen, can I just interrupt for a second?
Yes.
This is Ed. I just want to underscore what Karen's talking about here for a second, because I happen to be reviewing right now an IT report in which selecting officials for a position is quoted by staff as saying something along the lines of failure to hire a vet. I don't want to hire somebody who doesn't have a disability I can't see, right? Getting to thinking that a vet might have PTSD, mental disability. So, if we as lawyers representing clients find out about this stuff, we have to take appropriate steps to correct this perception. I was trying to make this happens, and if lawyers have a role to help clients think more clearly about the situation.
So Ed makes a very good point, and I have seen especially that it's the mental disabilities that there's more hidden bias there than there are for others, and that's when managers make bad decisions. But we'll get into that. So who may request an accommodation? So it's any person with a disability, someone with a physical or mental impairment, someone with a record of a disability. What does that mean? You know, if you've had cancer in the past, you have a record of a disability, and you might be entitled to a reasonable accommodation. And an individual associated with a person with a disability. If you have a disability and are at home, you're unable to ask for an accommodation, your relative can come in and ask for a reasonable accommodation for you, and so that's why that piece is there. Who is involved in the accommodation process? Congress intended that this process be an interactive one. It is not, as I say to managers, it's not a reflexive go to no.
About the last slide, or do you want to hold questions?
No, go ahead.
The person asking, does it have to be asking for the employee, or can you get the person who says to you, you know, my wife, my husband is disabled, and therefore I need an alternative work schedule so as to be able to care for them, even though I am not myself disabled?
No, it's for on behalf of the person with the disability. So, as I was saying, that it's an interactive process, and that means employers, the first thing they should do is not say, no, we don't do that, or no. It is to engage in this discussion with the employee, engage with the solicitor's office, engage with the EEO staff, and to say, what can we do for this individual, and how can we get them to a performance level where they're performing their job and they are able to do so because of an accommodation. So all of these people, the employee, the human resources, and EEO staff, the first line supervisor is instrumental in this process because they know what the employee's job is and what duties they have to perform. And of course, the solicitor's office, we always solicit clients in this because we don't want them to do it wrong. So we always try to be involved in the accommodation process. The role of the decision maker is to, as I said, engage in the interactive process. They can ask for medical information if necessary. The manager should be conferring with HR and EEO staff. They will approve at the lowest level. The EEOC says the manager at the lowest level should be making these decisions. That is not to say, though, that the upper management cannot be there to provide reconsideration if the supervisor denies a requested accommodation. And of course, the supervisor is there to also implement any approved accommodation. So here's the biggest problem, identifying requests for accommodation. Someone comes in and says, you know, my back's been hurting and I can't reach my file cabinets without hurting my back. And the supervisor shrugs his shoulder and says, well, you know, I don't know what to tell you. And that could be deemed as asking for an accommodation. The employee has expressed that they have a condition that may or may not be a disability and that they're having difficulty in some aspect of their job. So and managers have to be very uber aware that, you know, any mention of a medical condition or any difficulties performing the job, that may be seen, that may trigger the need to accommodate. Here are the rules. An accommodation may be requested orally or in writing. They do not need to say, I have a disability. They could just say, I have a back condition, or I have rheumatoid arthritis, or whatever the condition may be. The employee does not need to use the term, I am requesting an accommodation. They could say, I want a cart, and that would be sufficient to trigger the need to know that this is an accommodation request. As we mentioned earlier, a third party may request, may make a request on behalf of an individual with a disability. An employee may say or do something that suggests the need for something, and that would trigger the need to accommodate. And an employee may make multiple requests for accommodation. And they frequently do. They come in and they say, I want this, and 2 weeks later they say, I don't want this and this and this. And that's okay. They can do that.
If they don't identify the need,
If they're saying, I'm having difficulty doing something, and they don't say, what's the solution, then it behooves you as a supervisor to talk out, well, what can we do for you? EEOC is very lenient in terms of when a request for accommodation is being made, like how to define that. So I think erring on the side of caution, and whenever it may be implied that they are seeking help, that's when our obligation to help is triggered.
My name is Gary. Some of the specifics are my team job. There's heavy equipment, whether it's 10 pounds, 50 pounds, whatever have you. I think some of the PD requirements and the employees say up to 50 pounds, right? But while performing that job, they don't specify the actual request, but they just say something in terms of, I need to stay home for 2 days because my back hurts. In that case, although it's defined, how do you distinguish between that accommodation going forward because it's job requirement versus something of the other?
So job descriptions that have a physical or medical qualification standard are treated differently, because people can talk themselves out of a job if they say, I have this disability that doesn't allow me to meet the qualification standard. I mentioned before that people have to be qualified to be able to be entitled to a request for accommodation. So a good example would be the law enforcement officer who has to meet certain medical qualifications as an 1811 law enforcement officer and can no longer shoot a gun because of a disability. There is no accommodation you can give to that person to be able to perform the essential functions, because an essential function of that person's job is to shoot a gun. So that may be a situation where there's no accommodation, effective accommodation to give. And we'll go into that in detail about those situations.
What if an employee talks to a clerical staff, never says anything to their supervisor, the supervisor hears from the clerical staff that the employee is complaining about suitability? Is that a trigger?
I don't think so, but I think as a supervisor, what I would do is I would go to that. I've been hearing that you're having some difficulty or have some issues with the equipment, and is there anything that I can do for you? And I would just have that conversation, just like you would with any, in a normal management employee conversation. And if they don't want to talk to you about it, you don't force them to talk about it.
Who are in the room, if Karen's coming through all right, but the rest of you are faint to the point of inaudibility?
So the question, I will repeat people's questions to make sure everyone hears. What he was asked is, let's say that an employee goes to a clerical staff and is complaining about equipment or complaining about the suitability of office procedures.
Like the light.
Or, for example, the lights, and the manager hears about it. Does that trigger the obligation to provide a reasonable accommodation? I don't think so. Even the EEOC, I don't think, would want that to be requesting an accommodation. But my advice is to go to the employee and say, I hear through the grapevine that you're having difficulty. Is it something you want to talk to me about, and is there anything I can do? So let's talk about identifying the duty to accommodate. I gave you some do's and don'ts here. This is a very simple example because it illustrates the point about identifying requests for accommodation. Here, an employee is in a wheelchair, does not request an accommodation, does not discuss his disability, but his disability is obvious. And the employer goes and, for the holiday party, rents out a restaurant that has no second floor. There is an obligation for people with obvious disabilities to make sure they're accommodated, whether it's for training or for office parties or any other office events.
So you have to be cognizant. If you know of someone's disability, you have an obligation to make sure that they have an accommodation so that they can engage in the same activities as everyone else. It's basically leveling the playing field. And
Can I ask a question about that? And it's going to sound funny, but I'm somewhat serious. So suppose you had that same scenario, but instead of renting a place with just one floor, you say, we're going to have two people that are at the bottom of the stairs, and they'll carry you up, and they'll carry you down. That's the reasonable accommodation. So you can have access just like everybody else, but that's how we're going to, because otherwise we'll have to spend $5,000 or on some one-story building. Would that be acceptable, or is that the fact that the person would be carried up and down be
humiliating? I think so. I mean, at the end of the day, we can make it, it's all what is reasonable, and the EEOC is going to decide that, but if I were advising a client on that one, I would say no.
And there is a humiliation type component to it?
I think so. I think the EEOC would find that objectionable.
Okay, so you go off for it. For like today's event, for a hearing impaired employee, should we have had an interpreter out there?
Absolutely. Absolutely. Every training event we give, if it's open to someone that you know is going to have a disability, we have an obligation to provide those services. Did you all hear that question, by the way?
No.
No.
So the question was, so for this event, this training event, do we need to provide interpreter services or for individuals with hearing impairment? And the answer is yes. Anytime there's a training event, you need to be cognizant of who your employees are and whether or not they need any special assistance.
More specifically, I think, it was our hallway luncheon, and one of our employees is hearing impaired. So for like a lunch event that was for the office, we should have had an interpreter.
Yeah, the solicitor made remarks.
Yes. So whenever it's a broad event where, public, if it was just the food, I don't think so, but as long as there are remarks being made in a public event, that is available to all employees. Oh, okay, here's another example. An employee approaches the supervisor and says, I want a cart to haul files. And the supervisor says, well, why do you need the cart? And the employee says, I have a chronic back condition, and the doctor says I shouldn't be lifting heavy files. So the supervisor arranges the purchase of the cart for the employee's use. Employee came in and asked for something, did not identify that he had a disability, but the supervisor did the right thing by saying why. He didn't say a reflexive no. He said, why do you need it? And then once he learned of the disability, he provided the cart for the employee's use. Now, this is a good example of those things where a lot of people say, well, did he provide medical documentation proving he had a back condition? This is not something where you want to drill down like that for every single request for accommodation. If someone needs a cart, buy them a cart. Don't ask them for their doctor's notes to prove their back condition. I think there is a certain rationality to this process, and you should use good judgment in terms of when you ask for that medical documentation and when you don't.
But wouldn't this be a point to the hearing where say part of your job is you need to lift up to 50 pounds, and they say, I need a cart to do that. You buy the cart? I have a cart, I can do it. You buy the cart, or do you say, you're in the wrong job?
Well, the duty to provide a reasonable accommodation, the question is, if someone can't lift 50 pounds and it's in their position description that they are required to at least lift 50 pounds, and all of a sudden they can't because of a back condition, the question is whether or not they no longer can perform the essential functions of their job. They can perform the essential functions of their job if they have a cart.
Right.
so in that case, you do have a duty to accommodate them, because the question is, they're qualified employee or entitled to a reasonable accommodation if they can perform the essential functions of the job with or without an accommodation. So if giving an accommodation allows them to be qualified and allows them to perform those essential functions, then we're obligated to give it to them.
And is that true in the initial hiring then, too? I understand that in a situation where somebody lift 50 pounds, all of a sudden they get a disability. They still perform those jobs if you make a reasonable accommodation. Same individual comes in and says, I want that job, and I can do it as long as you give me a card.
That is a good question. So the question is, if you initially hire someone, is that also true? Do you have to hire them and give them an accommodation because of their disability? If you have a medical standard, you can refuse to hire someone because they're not qualified. But in this situation where they can do it with a cart, I think Schedule A employees, you may not know what those are. Schedule A employees are people with disabilities or targeted disabilities who get special consideration for hiring because of their disabilities. And we are required to consider them and to give them a leg up in terms of interviews and consideration for employment in an effort to increase diversity in that area. And so oftentimes the first thing an employer has to do when they hire a Schedule A employee is to provide them an accommodation. So the answer is yes. I think there's a distinction between medical standards where they have to get cleared by a doctor, like 1811, and someone who it's a condition of employment to be able to lift 50 pounds or more, but they could do that, they just can't. They have to have a cart, for example. I mean, the question really comes down to whether or not they can lift the 50 pounds and what the doctor says. But it's kind of a qualified answer.
What if the cart costs $2,000?
You all are anticipating what I'm going to get to, but the answer to that question is cost is rarely an excuse not to give an accommodation. And it doesn't matter how much budget you have in your particular office, they're going to look at the Department of Interior as a whole to determine whether the cost would cause undue hardship. And it rarely, the EEOC says, well, you got, millions of dollars, Department of Interior, billions. There's no reason why you couldn't have given this person. What's the next question?
Okay, I want to keep it dead horse, and I want to follow up the tax. I do have a question. We discussed being common sense, reasonable. However, what happens if an individual comes and they request some equipment or whatever, and it starts, now all of a sudden you have a person in DER that wants a particular piece of equipment. Somebody over here in WPG, he says, they want that equipment, and in this division somebody wants it.
Okay, so Emmanuel, who really cares about the subject because he's inundated with requests all the time for equipment, his question is this. I'm saying use rationality when you're deciding whether to force an employee to provide medical documentation. And he's saying, well, but it sets a precedent. One employee comes in and says, I need a stand-up desk. And then the next employee comes in and says, I want one too, and I have a back condition too, and he's saying, at that point, if you never ask for medical documentation, you may get requests that aren't reasonable. And I think you have to use your judgment. Emmanuel, if you feel like you need to ask for medical documentation because of the expense of the equipment, for example, if we're talking about a cart, I'm not sure, how expensive those are, but just use a little judgment and talk to me. I can kind of give my best off the.
Use a very real.
Yes. Yes.
So that's really helpful.
Yeah.
That's a really good point. Karen just said that if you've got a question, talk to her. Nobody in the solicitor's office who's dealing with a reasonable accommodation request should feel that they have to field that question or that issue alone, right? There's the division administration, Karen and her team, who can help you walk through whether or not the employee actually has an issue that is a reasonable accommodation or if it's something else. So please use the resources that are available to us to work through these issues.
Right. In other words, I'm always here. Call me. If I'm not here, someone on my staff. We deal with this all the time, and so we can give you. And we're not always right. I mean, we're trying to guess what the EEOC may rule down the road, but at the end of the day, it is a matter of judgment. And so, just getting a second piece of advice on this is always a good thing. So, here's another example. Employee orally asks a supervisor to telework 5 days a week. She indicates that she suffers from vertigo and that her doctor said that teleworking will help relieve symptoms triggered by her commute. The supervisor does not act on the request because the employee did not put her request in writing. And the answer to that is, nah, they don't have to put the request in writing. It's not a formal process. It's intended to be a dialogue between the supervisor and the employee. But I wanted to touch on some other things in what I wrote. We see telework requests all the time. Most of the reasonable accommodation issues we face are, I want to telework every day. I want a virtual, job away from home. And the commuting issue is a big one. I had a case once where someone lived in Michigan and commuted to Chicago every day. 5 hours, there or 5 hours total in the car. Of course she wanted to telework, and because her commute was so bad, and that was at her own choice. And so the supervisor is like, why should I let her telework when she chose to do that? It's amazing to me that EEOC has ruled that we have to consider people's commute if that's part of the issue. So they are not agency friendly, and so we have to consider the person, consider them the eggshell plaintiff. Whatever they have is what we have to consider.
Karen, this is Ken. I mean, that EEO decision, was that based on the merits of the supervisor's decision to not grant the accommodation, or that in that situation the supervisor or organization just didn't act on the request? So
what the doctor was saying is the commute, if I remember correctly, the commute's really bad for this person's condition. And the agency felt like, well, that's not our problem. They're not at work yet. That's their commute. That's on their personal time. We don't have to accommodate that. And the EEOC says, yes, you do. If providing a telework schedule would help, they're kind of considering the commute part of the job. And so that's something we have, if that is what's causing the problem, we still have to consider it for purposes of accommodation. We'll talk about telework more because that is such an issue, and how you apply that standard. Okay, here is a performance issue question. So an employee with a disability begins to have performance issues, and the supervisor meets with the employee to discuss the concerns. So you're not doing a good job, and at that point in time, the employee indicates that the disability is causing the performance problem. And at that point, the supervisor asks the employee if there is an accommodation that would help, and he asks for extra breaks during the day. And so the employee and the supervisor talk about it, and as long as that employee is working 8 hours a day, then that, giving breaks is a reasonable accommodation. The other thing you should know is you can't say, I can't do my job well anymore because of my disability, and therefore you can't judge me harshly for that. We don't have to lower performance standards. What we have to do is try to get them to the performance they need to be at through an accommodation process. But if they can't do it, we don't have to, rate them outstanding just because they have a disability that prevents their performance. Okay, the interactive process. I told you that we lose cases because of the failure to engage in the interactive process. It is mandatory. So if you deny a request for reasonable accommodation without sitting down and talking to the employee and having that dialogue, the agency can be found liable. So before you say no, we should, have that dialogue. And what does that dialogue look like? It goes something like this. All right, do you have a disability? What is that disability, and how does it limit your ability to perform the functions of your job? What are the essential functions of your job? The place to go for that is the position description, and we'll talk about that some more, about how important it is as managers to update your PDs and make sure that they accurately reflect what you expect your employees to do. Identify potential accommodations during this back and forth. Employee is going to come in and they're going to have an idea in mind of what they want as their accommodation. That's not the end of the dialogue, though. You can, if they want something, but it would be easier for the agency to give them something else that would be equally effective, that's okay too. And at that point, you determine which accommodations are reasonable and which are not, and you select your options. So that's what happens during the interactive process. So a discussion would be like this: what are your job-related limitations? What accommodations do you need? What are the job functions for which the accommodation is needed, and are those job functions essential? It's not up for the employee to say what the essential functions are. It's up for you. It's for you to decide that, and for your PD to decide that. It's during this process that you're going to determine whether you need medical documentation or not, and whether in the interim, while you're considering all of this, whether or not you need to provide interim measures, meaning in the meantime, I'm going to let you telework while we decide whether I'm going to allow you to telework permanently. So first step is determine whether the individual has a disability. My advice is assume they're disabled until someone tells you otherwise. We're not doctors, and most of you are not experts in this area, so it's not for you to say, that's not a disability, I have that, and I could do my job. At that point, you should treat them as disabled. It's safer that way, and then get advice. We do have medical personnel in various bureaus because we have 1811s and we have other medical needs. And so we can reach out to those doctors in terms of getting advice about whether someone's disabled. Under the ADA, most people who claim a disability are disabled. And I can probably guarantee there's probably half of us in this room who have a disability, including me. So just assume they're disabled and go to the next step. These are the disabilities, though. It could be physical or it could be mental, and that pretty much includes everything. So let's talk about requesting medical information. I say, we talked about this before, it's not always necessary. You're entitled to, but I think it makes you look unreasonable if you're always saying, well, I want you to document that. If it's obvious, for example, that they have a disability, don't ask for medical information. I told you you have the right to consult with medical personnel. If our medical personnel don't know enough about it, we have the right to give medical information to a doctor, an expert, to provide us medical advice. However, it will be at our expense. So the Bureau, or if it's in-house, we would have to pay for that. Okay, so the step 2 is talking about the limitations of the individual. That individual, that's when you have that dialogue. Well, what can't you do because of your disability? And explore with that person But, you know, can you, if that person's duty is to make copies and to do QuickTime and to do filing, those are the questions you should be asking. Can you do copies? Can you do QuickTime? Why can't you do QuickTime? And to kind of get a sense of how that person's disability is affecting their job. So if this is a list of kind of questions that you should be asking during this process. What you shouldn't ask, I'm going to, instead of going through all of these, what I'm going to do is tell you what not to ask. Don't ask their entire medical history. You're not entitled to know everything about their medical history. If they say their disability is, I have rheumatoid arthritis, you can't say, well, do you also have a heart condition, and do you have, you know, what else do you have? So don't go into there. This is not any of your business. So your business is to determine how their disability is affecting their job. So stick to that. And don't ask for medical information relating to all of their disabilities, only the one affecting their job. This is a standard lawyer thing. Document, document, document. Always, you know, if you are engaged in the interactive process, write a memo to self saying what was discussed, what they said, what you said. Make sure it's documented because this may be used down the road. Okay, what is an essential function of the job? That's key. We have essential functions and we have non-essential functions. Essential functions are the core of your job. Non-essential functions are things that you do on the side for fun or because your boss asked you to, but it's not necessarily what you were hired to do. So it's important to determine what the essential functions are, and we can talk more about that. So you don't have to remove essential functions as an accommodation. So the example I give, is the easiest example is the truck driver who is hired to be a truck driver loses his eyesight. There is no reasonable accommodation or accommodation you can provide that truck driver that will ever allow him to ever be a truck driver again. And that is an essential function of the job. He is not a qualified individual with a disability for whom we have to provide an accommodation. We might have to see if we could reassign him at that point as a last resort, find a job he is qualified for, but we are not required to say, okay, well, you don't have to drive the truck anymore. I'll allow you to sit at the reception desk. Yes, Emmanuel?
You have, let's say, an IT person, okay?
An IT person.
IT technician who is unable to lift a small arm to use, like the one that we don't currently have. That's a non-essential part of her. That's not so they can't lift a CPU.
Okay.
Which is IT equipment.
So we have an IT person who cannot lift CPU, which is IT equipment.
What if there's a question whether that is essential or not essential?
Well, again, judges will ultimately determine what is essential. If it's challenged, you err on the side of caution. But EEOC generally looks to what is in the position description. And position descriptions oftentimes spell out the big functions, and they may put at the end other duties as assigned. And that allows employers to give other duties to, which is fine. We can give other duties to our employees, but they are not essential functions. Essential functions are those that, as in the HR world, would allow that position to be classified as it is, as a lawyer job or as an IT job. There are certain critical elements that have to be in that PD, and that's for essential functions. An example I give is the secretary who makes copies and does QuickTime is asked to go to the FedEx store to deliver a FedEx package because we've missed the deadline here. That's not an essential function of her job, is to make deliveries outside the building, but it isn't something we've asked her to do. So does that help answer your question, Emmanuel? Well, if you have a specific question, you should bring me the PD, and we can talk about whether or not it fits or not. Well, I think the essential functions of an IT person are probably to perform the IT function, not necessarily to pick up things, but
Jack should be able to list his own speech. I will definitely be asking.
So let's talk about what is because Emmanuel was asking, when does it become an essential job function? So this is how it's defined, is an employee's position exists to perform that function, and the employee actually performs the function. So oftentimes you have, you look at the PD, you look at what they're supposed to do for a living, but you also look at what are they doing, because a lot of times they get into court and they say, well, that's in my PD, but I've never been asked to do that. I've never performed that job function in my life. That's why it's important for the employer to go and look at their PD, make sure it's up to date, and make sure it reflects accurately what they're doing. I had a case that I lost because the PD didn't mention this euphemism system, which is the accounting system that came into being like 3 years before, and they had never updated the PD. And the employee says, well, I don't want to use euphemism anymore. I have a attention deficit disorder, and it makes me crazy to have to count money and deal with the euphemism system. And the judge said that's a non-essential job because it wasn't in the PD. So lessons learned.
Yeah. Hey, Karen, is it also a function of what percentage of your work it is? Say it truly is essential, but it's only 5% of what you do. I mean, so a 40-hour work week, every work week might be a half hour. Will they take that into account and say, look, if the employee can still do 95%. Yes, they can't do that 5%, but you've got to just relieve them and get somebody else to do that 5% because it's so sort of de minimis. It's essential but de minimis sort of thing. Is there that sort of thing going on?
I could make the case. Oftentimes for PDs, Jack's asking whether, if it's an essential function, if they only do it 5% of the time, but it's an essential 5%.
Right.
Mary Grace, for example, putting together the weekly submissions. It may not be a big part of her job, but it is something that she does on a weekly basis for a period of time. I think a case can be made that any job functions that are set forth in the PD, even if it's only 10% of your time, is an essential function. Whether I'd win that or not, I don't know, but I think if it's outlined in your PD as one of the job functions, even if it's a small piece of the total, I think we could argue that that's essential. I could be wrong, but. So I give some examples of essential functions. So a secretary who has a limited ability to stand for extended periods asked to transfer his copying duties to another secretary. Make him do it because this hurts my leg. Copying is an essential function of the secretary's job. It's written in the PD. You don't have to transfer those duties to someone else and burden, because then, and that's called restructuring of the job duties. Now, if copying is not an essential function, yes, you have to transfer those duties to someone else and give him something that he can do. So it's really important to identify whether it's essential or not essential.
So on that point, if somebody makes a request like that and the supervisor tries to be a nice guy and makes the assignment to another secretary, is that by trouble?
Yes, it is, and that happens all the time. Lessons learned here from my perspective is we don't see the cases where the supervisors are giving the reasonable accommodations. They never come to us because the supervisor just gives it to them. And they do it probably because that employee is a great employee, is no problem, they want to make them happy, and they give them the accommodation. When we see it is when they don't like the employee is a problem, and they're somehow saying, oh, well, you know, why should we give them a reasonable accommodation? My guess is that happens a lot. And the problem is then they're treating people differently. Now it gets into a disparate treatment situation. So to Ed's point about are you getting into trouble when you know, don't follow these rules and you do restructure assignments because you're a good person, I think it does buy you trouble in the end. But people do it all the time. So what the supervisor can do is, well, I can't restructure the job, but I can get you a stool, or I'll try to find a copier that we can put at your desk so you don't have to stand when you do it. I mean, there are other things you can think of so not to get into that trick box.
Let me tell you about a situation we had here that sort of includes a lot of what we've been talking about, Karen, with regard to the interactive process. Also, it had a portion of hardship to the agency, as well as what is and is or might not be an essential function. We had a situation down in one of the parks in Louisiana, and both of these individuals, one of whom had a disability, the other one did not, and their PDs were identical. They were, for lack of a better term, they were tractor operators, I believe is what they were called. But they did a lot of grass cutting, and some of that cutting of grass was either on the tractor, using the tractor, actually a motorized tractor, as well as weed eating. And some of that weed eating was done on an incline. One of the employees had a knee problem, had a knee replacement or I believe a hip replacement. And he had all of the medical documentation that said he could not negotiate the incline in weed eating. And the agency wanted to take the hard position, in fact did take the hard position, that they could not accommodate him, and so this was an essential function of his job, and they wanted to go ahead and remove the individual. And at the hearing, the judge had a lot of problems, and one of the things that we had suggested that the agency consider was that they could actually swap out, at least consider swapping out, some of the tractor duties that they both performed. In other words, if there was 10% of this person's both of their time spent weed eating on the incline, and 50% on the tractor, they could actually give one employee, have this one employee do a little of both. In other words, to assume the other's responsibilities with regard to the incline, and then swap out that same percentage for the disabled employee on the tractor. And that was one thing that the judge, they were having problems as to why the agency did not consider that. And that was one of the things that we had recommended, and that was where we was headed. We were able to resolve it, but it was fairly clear that they were going to make a finding that the agency had not properly accommodated this person.
I think, you know, the rules are pretty straightforward, where you don't have to take away essential functions. How the EEOC treats that and how we should do it as human beings in the government is another matter. And I think when you draw the bright line every time, and Horace makes a good point, I mean, why are you drawing the bright line? What harm is it going to do to transfer these positions somewhere else? Well, sometimes it does matter. Sometimes it doesn't. And I think the judgment call has got to be made on a case-by-case basis. The example I had in a case was a laboratory chemist who was testing drugs developed an allergy to marijuana, and so they couldn't test marijuana anymore, and asked to do all the coke and meth testing instead of the marijuana testing. The problem is in that particular division, most of the drugs that came in were marijuana, and it wasn't cocaine and meth, and that left 95% of the work for everyone else, and a small amount of work for the disabled laboratory chemist. So you have to use your judgment. If that would cause an undue hardship to the agency in that circumstances, but in the circumstance that Horace is giving, it would not, because there's equal, I assume there was equal amount of grass cutting and weed eating, and so that sounds, you know, it all comes down to what is reasonable, and we have to use we just have to use our best judgment on that.
Can I follow? Because I think Horace's examples is a good one, because having spent summers cutting grass and weed eating, there's a big difference between riding a lawnmower and down on an incline using a weed eater. One's a lot more physically demanding, a lot more difficult, and so forth. And I could see if I was the Hale employee, why the heck am I having to do all this scut work for this other guy? I mean, that seems to me to then not just disparate treatment, but you have to change job description, right? This guy's a weed eater, and this guy's a tractor driver, you know? I mean, really, is that it doesn't, I mean, I could see an employee saying, no, wait a second, why should I have to, because this guy has a bad hip.
Right, well,
yeah, Horace.
I do have a bad hip, believe it or not.
Well, I think your point is, I mean, you do have to look in turn. We'll get to this, but when we talk about undue hardship, you look at the impact on the agency and the impact on the mission. And, you know, in the situation where you're making everyone do the marijuana testing, you're imposing a burden, you're affecting the work, and I think you can make a case for undue hardship. So the only advice I can give is it comes down to what's reasonable, and Horace is right. You know, most of the time, the EEOC is going to find that can't you bend a little bit, and that's the upshot of this area of the law, is you have to be careful. You can't
have an accommodating coworker.
That's exactly right. Okay, here's a non-essential function.
Actions with union contracts. If I see these guys with groundskeepers in particular being part of a union, then it being a definite case where you might have to talk to the union if you're asking the other guy to assume, as he said, more of the scut work. I could see him filing a grievance.
Yeah.
Right. Well, this area of the law, dealing with coworkers is one of the most challenging aspects of it. One, you can't tell the coworkers why you're doing what you're doing, and because they don't have a need to know. So it causes a lot of those problems down the road because you can't explain your actions as a manager. Let's move on, and because we're going to address that topic more later, let's identify potential accommodations. We are not required to provide the accommodation that's requested. We just have to provide something that is effective. But again, you know, don't do, well, if he's asking for it, I'm not going to give it. I'm going to give him something else. I mean, if you can give him or her what they're asking for, you should do that because it's just the right thing to do. So this is most of my examples are real-life cases. This is a case that I had where an individual with carpal tunnel who writes reports all day said, I want my own typist to write all my reports because I have carpal tunnel, and that would be very expensive to the agency. And so we offered voice-activated typing software, which is designed for that very purpose, and that was considered to be a reasonable accommodation. This is where you start brainstorming about other ways to solve the problem. And what is reasonable? So this is the definition. Accommodation will be considered reasonable if it will enable an employee with a disability to perform essential or non-essential functions of the job and will not cause undue hardship to the agency. So when is an accommodation not reasonable? If it would require the removal of an essential job function, if it requires the lowering of a job performance standard, if it would not be effective, meaning someone asked for something that wouldn't address the problem at all, and if it would cause undue hardship to the agency, which is a very difficult standard to meet. What is undue hardship? To satisfy the undue hardship standard, an accommodation must impose significant difficulty or expense. If the accommodation would cause extensive and substantial disruption to agency business, the accommodation may meet the undue hardship standard. There is undue hardship if the accommodation fundamentally alters the nature of the agency's business. And this is what I told you before, cost is never a good excuse. They will say, well, look at the agency DOI budget, and that's what they will go by. So if you have any issues with cost, take it up your chain, because you saying that you as an office don't have the money is not gonna cut it. So let's talk about time and attendance requirements. Horace, I think you probably agree with me that this is very common. Time and attendance and telework issues. So I gave an example of an employee with chronic depression, is continually late to work or absent from the office without advance notice, and the supervisor counsels the employee, and all of a sudden the employee says, oh, well, it's because I have chronic depression, and I want an open-ended schedule to let me come and go as I please. You can give and take on the time and attendance requirements, but we are not required to completely obviate the time and attendance requirements. An employee is expected to work, 80 hours a week, every 2 weeks, and you cannot just come in when you want to. So what you should do is sit down with your employee and say, work out a system that might be reasonable. Give me a call in the morning, and if it's getting to be where it's not reasonable, have another sit down with them in terms of how getting doctor's notes. Is this going to be a perpetual problem, and how can we solve this? So,
Karen, this is Matt McCowan. I've got a follow-up question about that.
Yeah.
If you have an employee, if the chronically depressed employee also happens to be a very high performer, is the answer that a manager does not have the discretion to sort of grant that kind of an accommodation because it would result in working less than 80 hours a pay period?
Well, if they have leave, they can take leave, of course. I don't think that in terms of waste, fraud, and abuse, that as a manager you can say that they don't have to work their 80 hours.
So right. I just want to make sure that if a manager said, but I'm willing to work with you on coming and going within the band of an 80-hour work week.
Right.
You can do that, right?
I think it comes down to just being reasonable about it. I mean, you're not required to say, I'm going to give you free rein. But if it's a high-performing employee and you can work out a system where you can keep accurate time of that employee, then yes. I have dealt with the situation by saying, why don't we change your duty hours? Why don't we have your duty hours start at 10 and end at 7, or work with the situation that way. Absences are a little harder to deal with, but my gut feeling is whether the employee is a good, bad, or insufficient employee, if they have a problem, work with them, because at the end of the day, when you do have to say no to something, you will have created a record that you've bent over backwards, and that is what you should be doing.
So, Karen, as you build that record, you talk about whether and how it's important to document the impact of the efforts to accommodate the employee, right? So, if, for example, you adjust the schedule, the flexibility of the schedule, and you see that work diminishes, the volume of work, the quality of work diminishes, how do you address that, right? You need to document what the impact of if at some point you have to curtail the accommodation because it's not working, you've got to be able to demonstrate why it's not working, right, or how it's not working.
Yes, and that's a good point. And Ed is saying documenting is very important to see how how the process is working, and if it's not working, to address it later. This is a fluid process. You don't say yes, and then it's, you know, a stagnant situation, especially when time and attendance or leave issues or telework. You can say, I'm going to give you an accommodation for 2 months, and we're going to see how that works and see if it's effective. You can do that. You don't have to, you can revisit issues, and you should document, you know, in writing to the employee, this is what I've noticed over the last 2 months, and I'm having difficulty with this. And remember, you still have to, you know, work your number of hours, or, and you should document performance issues, just like any other employee. Sure. This is not a situation where you should expect to have a substandard employee. That's not what this statute is all about.
Right.
Lori is telling me that I have to take a break, so why don't essential break. So why don't we come back in 5 minutes?
No. Huh? Dead.
See what it is.
Anything?
Are you?
So that's working.
Hang on.
That one's working.
That one's working.
Can we try that one out and then have it down? Yeah.
No.
Two here.
All right. So should I just take it out?
My very first case. Oh, look at this. Yes, my My very first chemistry as social counsel argued that that was just a personnel law. And I
So they
thought
might
that
as well
was
just
some
take it out.
buzzword, and I just didn't know what it was. And the judge looked at me and said, what's that? And it was so embarrassing. Like, he was just making it up.
No, it isn't.
And the accommodation he wanted was to do nothing. Well, I find it interesting that one of my examples is Horace's example. The gardener becomes allergic to plants, and okay, we're going to get started. I'm going to go through some of my hypotheticals since we've talked about some of them. Here is a real-life hypothetical that I had. Someone with rheumatoid arthritis provides a letter from her doctor indicating that an hour nap in the middle of the day would assist the employee in the performance of her job.
I volunteer for the hour nap.
I know, me too. And the supervisor said, you're here to sleep, you're here to work, not sleep, and denied the request immediately. And, they were chagrined to find out this might be a reasonable accommodation. So, as long as they're working an 8-hour day, so, Mike, I'd like to take a nap every day if that's okay with you.
Bring in a hammock.
Okay. This is close to a situation that was encountered here at the solicitor's office. A park ranger had PTSD and did not wanted full-time telework as an accommodation for PTSD. And his essential job function is provide guided tours. He can't do that from home. That's an unreasonable request for accommodation. That one's an easy one.
Have you been reading our mail lately?
No.
We have this exact case.
Okay.
Yeah, some of these recycle.
Wow. Call me about that one. I'd be interested.
As you say, it's a relatively simple case, but in the end, but yes.
So let's talk about reassignments, because we can lose cases because managers have a reflexive, well, if you can't do your job anymore, we'll just put you in another job. And it should only be a last resort, meaning you have to provide any kind of accommodation you can to get that person to be able to perform the essential functions of his or her job, and only if that is unsuccessful can you consider reassignment. And if you look around your office and say, I have no other jobs that this person can go to, and you don't look further, you can be liable. You're required to, it's kind of concentric circles. You look in your office for a position that's available, and then you go further out, and ultimately you have an obligation to go all the way to the department level to see if there is any job that this person can perform. And it may be a demotion, but they have to be qualified for it. They are not entitled to, Ed's job, or, if they're not qualified for it. All right, granting a request for, there's some resources available, and I apologize because I don't know what all they are here in the department. I will find out for you if you need have some questions about implementation. But I do know 2 resources that are available to everybody. And one is the Job Accommodation Network, JAN. I've used them on numerous occasions. They have people at a 1-800 hotline, and you can describe your situation and say, what other accommodations might be effective for this type of disability, for this type of job, and they are very helpful.
Does that cost anything?
Nothing. Costs nothing. It's part of the Department of Labor. And so, you know, I suggest that, you know, they often consult with applicants and employees, and they may find something that is reasonable that you don't think is reasonable, and that's okay. This is just somewhere where you can get advice. The other resource is CAP. It's a Department of Defense Computer Electronic Accommodations Program, and I believe the Department of Interior has a contract with them to help provide it's mainly for technology-based accommodations. So, for example, if you are vision impaired, they can maybe get you special screens that will help you see your computer. It will help people who have hearing impaired with phones, stand-up desks, special ergonomic equipment, and they are located at the Pentagon. And I set up an appointment. I can have them come out and give a presentation if you're interested, but they have a lot of cool gadgets for people who need them. So if you ever have an employee who needs special equipment, you can set up an appointment. They do have to provide medical documentation before they can get that equipment, however. And we talked about payment. That's us. We have to pay for it. And so just go up through your chain of command if it's too costly for your budget. Okay, denying a request for accommodation. The request for accommodation does not need to be in writing. The denial of an accommodation request does. So make sure that if you don't just go into their office and say, sorry, I'm not giving it to you, also put it in writing. I mean, I'm not saying you can't have that conversation with the employee, but make sure that the denial is in writing because then they have the right to file an EEO complaint if you deny it.
And make sure it's reviewed by HR.
And solicitor's office, me and my staff too.
Is an email considered writing?
That's in writing. That's in writing. You have to set forth the reasons why you're denying the request, and the denial should be provided to the employee. They have the right to seek reconsideration. Typically, it's the first-line supervisor who is engaging in this dialogue with the employee, but they should, I think it's always safer to allow them to seek reconsideration from someone else, and so I would offer that to go to the office head for reconsideration. And also, you should inform them of their right to file an EEO complaint because they do have such a right.
Hey, Karen, this is Matt again. I feel the need to interject there. The other thing I was going to add was, having granted many and denied none, my suggestion to managers, if they're really going to deny an accommodation request, would be to look within for a minute and ask, why am I doing this?
Yes.
That's a good point.
In other words, it's not the reflexive no. I mean,
Well, just try being an actual human being.
Exactly. Okay, so reasons for denial of a request for accommodation, we've kind of gone through some of these, but, you know, is the person not qualified? There is no medical documentation proving that the person has a disability. There is some question about whether a person with a temporary disability is entitled, meaning I broke my arm, I'm going to be in a cast for 6 weeks, and versus a permanent disability. The EEOC has come out with some troubling cases that might suggest that even temporary disabilities, maybe not a broken arm, but some other things that may go away. For example, I'm going to go through back surgery first, and I'm going to be just, hurting for 6 weeks or 6 months or whatever. So, as I said, I wouldn't even look at the factor of whether they're disabled. As far as medical documentation, it's not to prove they have a disability. What it is, what you want the doctor to do is try to identify for you what would truly be an effective accommodation. That's what the doctor can do for you. Because sometimes I will write the letter to their doctor, and I will say, please answer the following questions, yes or no. And I will say, can they do, copying, yes or no? Can they do? And I will enumerate all of their essential functions. And that way the doctor knows specifically, and then I have the follow-up question. In what way are they limited from performing that function? So that's really where doctors come into play. If you start questioning the doctor's view that this person is disabled, you're going to lose that. And you will find that most doctors will say whatever their patients want them to say in doctor's notes. So that's a lose-lose for us if we try to go down that road. Yes?
Is it reasonable to ask that the note include a piece of equipment? What kind of equipment, make and model? Because in the past, there's been an individual that requested some equipment to help them perform their job, and it was essential. When they got the equipment, they didn't like the equipment, so they asked that something else be ordered. And it happened like 3 or 4 times. When the individual finally left the organization, there were like 3 boxes that had never even been opened.
Okay, did you all hear that? Yes? Okay. So I guess my answer to that would be have that dialogue with the employee saying, we're thinking about this equipment. Can you confer with your doctor to see if that would if that's going to be effective? Again, you don't have to provide the exact accommodation they're requesting. If you find a make and model that essentially does the same thing, that may not have all the bells and whistles, but would be an effective accommodation, you're not required to get exactly what they want. But on the other hand, if, as Matt said, be human, use your judgment. If you can give it to them, you should give it to them. But, in terms of them saying, well, I ended up not liking this equipment, I want something else, I think that having that dialogue first will help stop that process. I mean, to the extent you can have them test drive some things first, find out if some other people are using it, and see if they can like it, and then before you purchase it. But we do have some deadlines here, so you can't spend too much time, in the back and forth. We have to act pretty quickly, and so let's go moving forward. We've talked about this. You should also put in writing if you give an accommodation but deny their requested accommodation, because that's still a denial of an accommodation. So they can still file an EEO complaint if you give them you don't buy them the typist or get them the typist, but you buy them the voice-activated software. That's still considered a denial, even though you've given them an accommodation. But you're going to win that case because you gave an effective accommodation. Okay, so here are the timelines in the Department of Interior, and they're pretty fast. Not quite as fast as the Department of Justice, so we're lucky, but you have 10 business days. I guess that's for HR. If HR gets the request to send it over to the supervisor or manager, the manager has 15 days to issue a written decision, unless they ask for medical documentation, in which time they get 10 business days from the receipt of that medical information, and then they have 20 business days after granting the request to actually purchase the equipment or provide the accommodation. So bear in mind that this is not amorphous. You can't sit on it. You can't delay. You have to act speedily. Every example I've given, are the lessons learned that I've learned through case law. Maintaining confidentiality is a big one.
About the deadlines, I could see 20 days, and I've had cases where you've got equipment that's on order, it takes longer than 20 days, it could easily, does it have to be in place, in effect, after 20 days, or does it have to be ordered and in process within 20 days?
I think implementation means implementation. What I would do is I would do an interim accommodation, saying that, you know, until such time as we have the equipment, I'm going to give you light duty and not make you, you know, and try to think outside the box and give them other duties while you're waiting for the equipment to come in. That's how I would deal with that, if it's possible. All right, so maintaining confidentiality. This is where we get into those coworkers, those pesky coworkers who are saying, why are you not treating me the same way? And I think in our senior management meeting we talked about the need to know and how that comes across. Well, this is a situation that you can get in big trouble if you don't say, I'm sorry, I can't discuss it. There are specific provisions in the Rehabilitation Act that deal with confidentiality and maintaining privacy, so take it very seriously. The people with the need to know would be the office of the solicitor, the EEO office, people in the chain of command, and any medical personnel.
Hey, Karen, I assume the person can waive that, though, right?
They can waive that. They can file a, you know, like a HIPAA release for their doctor to give information, and they can do a Privacy Act waiver for the information. But I certainly would get that in writing before I revealed anything about someone's disability.
Can they waive it by talking about it openly and as far as to help?
I don't know the answer to that question. I think that if they do, I would still be cautious about talking about it with other people. Just to be on the safe side.
What was the question?
The question was whether or not if they talk about it, do they waive their Privacy Act rights? Or the privacy provisions of the Rehabilitation Act. If they are blabbering to everyone about their disability, does that give you license as a manager to then discuss it? And I think the answer is no. But I'm not sure of the answer. I've never addressed that issue.
I had it come up in my office in a real kind of indirect way because of the obviousness of a stand-up desk, right? Because it's there. Everybody can see it. And so we just opted not to address why a certain employee had one, and as additional requests came in, we bought more as our budget would allow.
So that's a good example. I have a slide here on how to address accommodation issues with employees' coworkers. And an example I had is someone with attention deficit disorder who wanted their own office because it reduces the distractions, and instead, as an accommodation, they built up soundproof walls around a cubicle in an open space, which was, you know, in the middle of an open space, and all of a sudden they had these cubes build up, and everyone was like, why are you doing that? And the supervisor had to say, I'm not at liberty to discuss reasons why I took this action, but, you know, ensuring that it had nothing to do with them, but that they can't discuss it. And that's just got to be the party line, is can't discuss it. The bigger question is whether when they got the office, when they gave the person the office, and then the employees are like, I want the office. I want my own private office. And you're going to have to deal with that issue and just say, I'm not at liberty to discuss this. But it was made as a management decision, and you know, and you may get lawsuits over it. You may get disparate treatment claims. You may get EEO cases that arise from that, but you'll have a very good defense at the end of the day.
So you can raise that as defense? You're not violating the person's privacy?
Sure.
Yeah, you can. There are exceptions for, and that certainly is a need to know. Okay, this is another doozy, because it's counterintuitive. You would think that, you know, you have a drop file in your desk where you put all of your employees' notices of personnel action or performance evaluations, and you keep them all, you know, in a separate file based on their name. But it would be against the law for you to put your reasonable accommodation material in that same file. And most people think, well, they're both privacy protected, but they should be maintained in a separate file. And the reason is that the the supervisor may up and leave, and that file, that drop file with the personnel actions may go to someone else, and they want to make sure that those accommodation files are kept separate and apart and don't get disseminated. And we used to have a rule at DOJ that we're supposed to take those files after the employee leaves, or and send them to the EEO office for safekeeping. I haven't figured out yet what the Department of Interior process is or what it should be, but just know that if you have an accommodation request, you should create a separate file. You should keep it under lock and key, and you should put all medical information and all information relating to the request for accommodation separate and apart from any other file. All right, so we are a little early. Thank you. True or false questions, and I'm going to actually make you answer before I go to the answer. So, employees and applicants are required to put their request for accommodation in writing before their request must be considered. True or false?
False.
False. Requests for accommodation need not be in writing, and they do not need to use the term accommodation or disability. And no cheating, Mike, by looking at the PowerPoint. Okay. True or false? The agency is not necessarily required to provide the accommodation requested by the employee or applicant. True. But granting the accommodation requested should be considered if it would be effective and would not cause undue hardship. Don't go to the reflexive no. True or false? The agency does not need to eliminate essential functions of an employee's job as an accommodation.
True.
True. It is not reasonable when it requires the elimination of legitimate selection criteria, lower standards of performance, or reallocates or eliminates essential job functions. True or false? As long as an employee's position description lists other duties as assigned, any assignment that the supervisor gives to the employee would be considered an essential function of the employee's position.
False.
False. Exactly. It has to be a job duty that is set forth in the position description, and other duties as assigned would not be considered essential functions. True or false? If the office where the request for accommodation originated does not have sufficient funds to implement the accommodation without compromising the funding for existing office programs, the accommodation should be denied as being too costly and an undue hardship to the agency. True or false?
False.
Yes.
Well, explain to me, though, I mean, we have a limited budget, and DMR has it, and the SOL as a whole has it. Is there a way to elevate this stuff to the department as a whole?
I think you do. I think that's exactly what you do, and you make the argument that it would hurt existing programs, and you're going to need, this is an obligation under the law, and you department should give us funding to fund this. Now, I don't know how successful you're going to be, but
Yeah, we've had those conversations. We've had conversations with other bureaus and staff and taken up the
And do they
goes up to the staff level, yeah.
oh, did I already do this one? If an employee requests that he be relieved of performing certain non-essential functions of his job due to his disability, the supervisor can reassign the employee to another job as an alternative accommodation. False. Reassignment of an employee may only be considered as a last resort. It's only after you determine that no other accommodation will enable the employee to perform the essential functions of his or her current position.
I think the tricky thing there is we obviously see situations where the employee would love to have the different job, and so you're not forcing the reassignment. You can certainly do that with the.
And you can do that. If they request that accommodation,
Right.
that's okay. It's when they don't request it,
Right.
you say,
Trying to force them.
right. True or false? A supervisor should always ensure that the records related to an employee's request for accommodation, including his or her medical records, are maintained with other privacy-protected records that the supervisor may maintain on the employee, including performance evaluations, any discipline records, and all notices of personnel action. All. It should be in separate files. And it is a violation of law to disclose medical information to anyone without a need to know. True or false? Even
True.
Even if the supervisor has good reasons for denying a request for accommodation, the agency could be held liable for failure to accommodate when a supervisor denies a request without first discussing the request with the employee and engaging in the interactive process.
True.
True. Okay, agencies are required to engage in the interactive process. True or false? The supervisor is required to decide promptly whether to approve or deny a request for accommodation. True. And here are the deadlines. True or false? It is advisable for a supervisor to inform an employee or applicant verbally and in person of any decision to deny a requested accommodation rather than setting forth the reasons for the denial in writing.
False.
All denials of an accommodation must be in writing and set forth the reasons for the denial. Thank you. That's it. Do you have any other questions?
Thank you.
Thank you.
I'd like to, in the few minutes I have left, I was asked to help put together this training so that you all can comply with your diversity and EEO training. And I have some other ideas for some training modules if you want, rather than having to go online and do it online. So I wanted to get your thoughts on that. One of the ideas for diversity training was to talk about best practices for interviewing and hiring. And I thought that would fit nicely with diversity because, you know, it's talking about how to treat people fairly. And so what do you think about that as a topic?
Excellent. Timely. Wonderful.
All right. Another topic would be on performance and discipline of employees, and that would be a 2-hour piece explaining the importance of being honest in performance evaluations and how to deal with difficult employees. I think it's something that all managers have to face at some point or another, and we deal with it daily with managers out in the field. Is that something you would be interested in?
Yes.
Yes. Okay.
Before performance management.
Okay. So we were going to have a 2-hour on that somewhere down the road. And then the other topic, I thought we could describe the EEO process. It may be, if you're lucky, you haven't gone through the EEO process before, but we can explain how it works through the system and what are the implications for the managers who are engaged in the EEO process and what are the repercussions. That would still fulfill at least 1 hour of EEO. We would also touch on 1 hour of whistleblower retaliation. That's another big one for us. I think whistleblower and reasonable accommodations are the two most difficult topics. So we would do 1 hour on that. And where does that get us in terms of hours? So you have EEO is 1, whistleblower is 1, discipline and performance is 2, so that's 4. Best practices for interviewing and hiring would be 5. This is 2, and then I was going to. We have USERA, which is online. So everyone has to do USERA training, and I figured we could just do that one online. But that'll at least give you another 7 hours total.
Which ones are, like the first one was diversity.
So best practices on hiring is diversity. Performance and discipline would be diversity. Whistleblower, let's put that under diversity, and the other one would go under EEO.
Why would the performance one be under diversity? It's just management.
Yeah, but you know, I think part of management is retention of employees and promoting diversity, and how you manage impacts that. I just thought it was a more practical subject matter that would be helpful.
Diversity and rating, not everybody's on one.
topic that I see all the time, and I think if you learn how to deal with people in that environment, it promotes diversity because it promotes, you know, you have different people with different skill sets, and you have to learn how to deal with them differently. So that was my thought anyway. Does anyone on the phone have any comments on that? Whether you think other topics would be more worthwhile?
Yeah, I have. Go ahead, Matt.
Oh, thanks. I was just going to say that all sounds great. And could I clarify the online USERA training that we all had to do? Does that count towards our 8 hours total?
Yeah, 1 hour EEO training.
Thank you. Go ahead, Horace.
Yeah, I think one topic, and we do it here in the Southeast. We have been working with the department, and Isaiah Delamar in this office has been doing training across bureau lines, and that would fit within the diversity, and that has to do with the barrier analysis, and that would fit right in with hiring and promotions and other personnel actions within that we all deal with as managers.
Okay.
I would suggest that be something that we consider.
Okay. Do you think it's an hour topic? Can Isaiah do it?
Yeah, he can. I think we can adapt it to fit what it is for our needs. Yes.
Okay.
But I can get with you on that offline.
Perfect. Okay. Well, thank you all.
Thank you, Karen.
Thank you.
Yeah, thanks a lot, Ms. Joe.
Yeah.